Okay, did you?
Testing 1 2 3. Testing 1 2 3. Test test test. Testing. Okay. Okay.
Right. Yeah. Michelle, just be prepared. It looks like it's probably gonna go. We'll switch real quick. They'll have. Okay. Yeah, we can't do the Zoom group. Guys from us. Okay. Okay. Yeah, yes. Ben and Adam, you're in here, right? Okay, yeah, but you're all, in case things switch around. We have both the other cases. It's the. Yes.
Hey, Ellie.
Yeah.
Ellie, can you mute the podium? Mute the podium.
The Honorable Judge of the United States Court of Appeals in and for the Seventh Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention as the court is now sitting. God save the United States and this honorable court.
Good morning, everyone. We're here for oral argument this morning. I understand we're missing some attorneys on the first case. Is that correct? Okay, so I'm going to ask counsel in the front row if you would please step back, and we're going to start this morning with the second case first, and we'll get back to the first case when all counsel is here. So our first case for oral argument this morning is appeal number 24-2161, United States versus Collins. Good morning, Ms. Gambino.
Good morning, Your Honor. Good morning, Judge St. Eve, Judge Lee, and Judge Kohler. We are here this morning because Ms. Collins was deprived of a right to a fair trial because the district court made 3 decisions at least, which interfered with her ability to exercise her Fifth Amendment right to testify on her own behalf. And I'm going to focus my argument on 3 of those decisions this morning, unless the court has questions about other matters. So first of all, there was the question, motion in limine was filed by the government seeking to keep out the fact that Ms. Collins had amended her 2015 tax returns and begun an installment payment. And the reasoning behind that decision by the district court was this court's decision in Beavers. And in Beavers, of course, that was done because the court in that case found that Mr. Beavers decision or remedial action could either be considered an effort to cover up the failures or an innocent mistake.
So would we have to overrule Beavers in order to find for you?
No, you would not have to overrule Beavers. It is our position, Your Honor, that Ms. Collins' case is distinguishable from Mr. Beavers' case in a very important way. And the first of those is the timing of the decision. The court in Beavers said that Mr. Beavers failed to act until he had been interviewed by federal agents. And that certainly wasn't the case in Ms. Collins' case. First of all, Ms. Collins rectified her problems with her filings based on a civil notice from the IRS that she had misreported her income.
But wasn't it still based on notice from the government? We might have a different argument if you came in here and said on her own, without any notice, federal, criminal, otherwise, she amended them and realized her mistake. But it seems like the logic of Beavers that she didn't take any action until after she had notice from the government would apply.
Judge, I think respectfully, I would disagree with that in this particular case, because I think there is, and this court has found, that there's a difference between a civil notice and a criminal notice. In Mr. Beavers' case, it was federal agents that were criminally investigating him. In Ms. Collins' case, it was a civil notice that is given in the ordinary course. And these civil notices are given to give a taxpayer an opportunity to rectify mistakes they may have made. And I don't think that it's equivalent because as the court found in Tisher, remedial action, for instance, after an audit, but before an investigation, showed good faith effort to correct innocent mistakes. If you don't distinguish between the civil notice and the criminal notice, then every time there's any notice, a presumption of criminality would inhere, and taxpayers would have no incentive to respond to a civil notice by correcting their mistakes if they knew that was going to be taken as an admission of criminal liability. So I think that you have to separate civil notice from criminal notice.
It's not really an admission of criminal liability, is it? I think the question is more is how relevant, if at all, are the remedial measures to determine her state of mind at the time the original tax filings were filed. And so I don't think anyone is arguing here that the government would use the remedial actions as an admission of guilt or liability. It's just more kind of a different question, which is whether or not those remedial measures would be admissible. But how are we to deal with the 403 aspect of it, right? So it's not as though she just paid it and amended her 2014 tax returns and that's that. There were some convoluted facts about whether or not she amended the right return, and then when she did amend the return, she added additional deductions. If Ms. Collins was allowed to testify as to that, I take it that the government then would be able to cross-examine her with regard to all of these other factors, right? And then it seems like that would just bring up a whole host of other issues that the district court thought might be tangential to the case. And so can you respond to the district court's 403 weighing of the fact that the facts aren't as clear-cut as she paid a check and that was that? There were a lot of other things kind of going on involved.
Yes, I think that basically with respect to Ms. Collins' case, she wanted to be able to admit that to show that she had a good faith intent to deal with her taxes legitimately. And even though there were mistakes, certainly, and there were complicated factors with what she did when she did amend them, I think it still is relevant or probative of her intent that she wanted to correct mistakes that were brought to her attention.
So would the government then be allowed to cross-examine her with regard to the additional deductions that she had not previously claimed to try to zero out that additional income for the year that she was trying to amend?
They would certainly be free to cross-examine on that, and she would be free to explain the circumstances under which the mistake was made.
And similarly, with regard to the repayment plan that she, as I understand it, did not complete, would the government be able to cross-examine her on that and why she stopped paying?
Certainly that would be fair game. But I think the important thing to her would be able to, for instance, if her reasoning for failing to file or include information correctly the first time around had to do with certain life circumstances or the failure of her accountant to include matters that she had provided to him to include in her taxes, that would certainly be relevant and might take away the reasoning for the cross-examination that you suggest. We simply don't know. And so with respect to those concerns, the court's balancing was premature, particularly when at issue is whether the defendant is going to take that into consideration as an impact on her decision whether or not to testify. So you've got a Fifth Amendment right in the balance.
No, I understand. And I guess that kind of raises a broader question with regard to the standard of review here. So under Luce, the Supreme Court distinguished between whether or not the decision under review was a evidentiary one, right?
That's correct.
Versus whether or not it was a constitutional one.
That's true.
And one might quibble about how exactly to draw that line. But how would you draw that line between whether or not a evidentiary ruling by a court that impacts, right, that might factor into a defendant's decision to testify or not, whether such rulings are, in your mind, would they always have constitutional weight, or would there be instances where they would purely be evidentiary? And if so, how would you draw that line?
Well, I think that that would.
And I'm sorry, if I could just kind of augment that.
Sure.
So for example, a court might rule about the admissibility of other witnesses' testimony.
Right.
And certainly a defendant would think about that as well in deciding whether or not to testify. So for example, whether they're a witness who would be offering contradictory testimony that the defendant would proffer, whether or not the court would admit that witness. And so there's just a slew of things that would happen in a trial and evidentiary rulings in a trial that would factor into a defendant's decision whether or not to testify. And so how are we to decide whether or not those types of evidential rulings should be reviewed as, impeding a defendant's constitutional right to testify versus just straightforward evidentiary rulings?
Well, I think that that would depend greatly on the circumstances of the case. In this particular case, because the evidentiary ruling is something particularly within the knowledge of and concerns the actions of the defendant, you have something that's much more circumscribed than you would just any other 403 ruling with regard to other witnesses. Certainly, it's true that whether one witness testifies one way or another or is limited would have an impact, but not as direct an impact as whether the defendant can explain herself what she did and why she did it. And so I think in this particular case, you have a narrower subset of the hypothetical that you're posing to me, that when.
So what's the rule you're proposing? Where's the limiting principle on this?
I think the limiting principle would be whether the subject matter is relevant directly to the defendant's testimony or the evidence the defendant would like to bring, as opposed to
Doesn't that contradict Luce?
I don't know that it contradicts Luce exactly.
Because it was a defendant's testimony. And that was at issue, and they made evidentiary rulings under 609A about the defendant's testimony. So your proposed rule seems like it would conflict with Supreme Court precedent.
Well, I thought the focus of loose was the use of impeachment by conviction under 609B, which is not necessarily, I mean, that's a different matter.
Well, it goes directly to the defendant's testimony and issues relevant to the defendant. So if that's your limiting principle, that it should apply just directly to things the defendant did, or that might implicate the defendant's testimony as opposed to another witness's testimony, I think that runs afoul of loose.
Not if you limit it to as in this case, the evidence that the defendant would like to raise. You know, we're talking, loose dealt with what the government could do or not do in terms of evidentiary rulings that would prejudice the defendant. In our case, we're not looking at evidentiary rulings that would, that are based on what the government wants to do. They want to keep her from being able to put on a particular defense.
So for example, if a defendant wants to offer plainly hearsay testimony and the court, sustains the objection and precludes the defendant from offering hearsay testimony, would that also implicate a defendant's Fifth Amendment rights?
Well, it possibly could, although it wouldn't be in the same category because hearsay is only admissible under certain circumstances.
Right, but they're evidentiary rulings, right? I'm just trying to figure out, as Judge St. Eve says, how do we determine whether an evidentiary ruling deserves de novo review versus abuse of discretion review?
Versus waiver even, as in loose, where the defendant didn't testify and the court found he had waived his right to raise any kind of challenge.
Yes, I understand that. That's a more problematic issue than the one that we're addressing with respect to Ms. Collins.
But I don't think you can separate them, given the Supreme Court's precedent. If we're looking at standard of review, is it a question of waiver? Is it a de novo review? Or is it an abuse of discretion?
Well, I would call it de novo review, and I would call it that because of the, I mean, certainly in the first instance, it's abuse of discretion. That's pretty clear. But if you were to analyze it differently, you could call it de novo review because of the importance to the defendant, not to the government, of the evidence the defendant wishes to admit, not evidence that the government wishes to admit and the defendant wants to keep out. I do think there is.
You'd be proposing the same rule, even if this was a 403 objection on something that the defendant wanted to address in their testimony. Is that correct?
Yes, except unless, barring Judge Lee's example of hearsay, which has a whole set of other rules that go along with it. But yes.
But I take it from your view then that even under hearsay, in hearsay area, if a court precludes a defendant from testifying as to whatever the defendant thinks is relevant to the defense, that would have constitutional implications. I'm not saying whether that's right or wrong, just saying that would be kind of a logical conclusion from what you're arguing.
It is a logical conclusion that it may, yes.
Thank you, Ms. Campino.
The second issue.
You have 18 seconds left. We'll give you a little bit more for rebuttal.
All right,
we've asked you a lot of
thank you very
questions.
much. Thank you. I will reserve my little bit.
We'll give you a little bit more. Good morning, Ms. Partham.
Good morning. May it please the court, Michelle Partham for the United States. The district court properly denied defendant's motions for judgment of acquittal and a new trial, and both her conviction and her sentence should be affirmed. The district.
Do you have a view on, I would love to know your view on the question that we were asking Ms. Gambino with regard to the line between whether a ruling is only evidentiary versus whether it raises constitutional concerns.
I think this is a little bit of a tricky question. I agree, Ms. Gambino conceded that the first level of review for an evidentiary issue like this is going to be abuse of discretion. The government agrees with that, and that's the appropriate standard of review to apply here. The thing that's tricky is when a defendant is seeking to admit some type of evidence during a trial and they are appealing the preclusion of such evidence, one can always argue that that had constitutional implications. And it's certainly not the case that a reviewing court applies de novo review to every single evidentiary decision that disadvantages a defendant. So the government feels that abuse of discretion is the standard that should be applied for these types of evidentiary issues. And when a defendant makes the argument that their constitutional rights were infringed as a result of evidentiary rulings, the court also needs to bear in mind the principle that evidentiary rulings that truly do infringe constitutional rights are reviewed for de novo review. And so kind of bearing both in mind at once. And when the evidentiary rulings are as kind of straightforward as they are in this case, the court doesn't need to go to that second step, or the second step becomes very easy of seeing that rulings that were well within the district court's discretion did not infringe on the defendant's constitutional rights.
And sorry, go ahead. What are you basing that on? That if we look at abuse of discretion, that if there was no abuse of discretion, that's it, period? Or when would we go to de novo? And are you also arguing that because she did not testify, she waived that constitutional right as came up in Luce?
So turning first to the latter portion of your question, yes, because the defendant did not testify, under Luce and other circuit courts have applied that in the context of 608B, the defendant has waived her right to challenge the 608B ruling. That doesn't amount to a waiver of any constitutional claim, whatever. Certain aspects of her challenge are preserved as she has argued. And so in terms of figuring out when to apply abuse of discretion and when de novo, I think it requires looking at the challenges that the defendant has raised in light of the record. And so, for instance, if a defendant was entirely precluded as a result of evidentiary issues from raising a defense and being able to put forward a defense theory, that would be a stronger case for taking a second look under the de novo standard for whether their constitutional rights were infringed. But that's not the case that we have here. Here, Ms. Collins' primary defense was that her false statements were inadvertent. They were non-willful. That was a theme that was presented and pressed throughout the entire trial and was put forth through the testimony of her expert, Craig Green, who was able to testify essentially based on her out-of-court hearsay statements, notwithstanding the rulings precluding those, that her accountant was to blame for her false filings and that she had not acted willfully. And so that defense theory, that defense theme was presented throughout the trial. And in fact, where the defendant here is objecting to the preclusion of her amended tax return, it's worth bearing in mind that is a return that actually did not support her theory because of the false statements that were in the amendment. And so that fact is relevant both to the relevance of the amendment and, of course, to the 403 balancing, and shows why the district court properly precluded that evidence. This case is very similar to Beavers. It is not distinguishable on these bases because the defendant, as Judge St. Eve noted, was put on notice by the IRS notice that her false statements had been discovered. And so subsequent remedial actions she took after that notice are more consistent with attempting to avoid punishment for wrongdoing than with correcting a genuine mistake from the outset.
If I can turn back to Luce briefly, we haven't extended that to 608.
That's correct.
And you're asking us to do it here. But what would be your limiting principle for when we have to find waiver if a defendant decides not to testify?
I think the principle is that when a defendant is challenging a preliminary ruling pertaining to their testimony, they need to testify to create the record that would allow this court to review. Perhaps there's a situation that I'm not immediately thinking of where it wouldn't be as fact dependent how things would unfold. But in this case, we don't know whether the government, well, first of all, we don't know what the scope of the defendant's direct examination would have been if she had testified. And then we don't know what the government may have done, what limitations the district court may have put in place. And so to reverse and have to order a new trial on the basis of an argument that was raised and then resulted in the defendant declining to testify would create an incentive to basically plant reversible error, which is what one of the concerns that the loose court noted. So I think the limiting principle or the organizing principle would be, can this court meaningfully review the decision? Was that decision allowed to develop and create an evidentiary record that would allow the court to determine both whether it was in error and also whether it was harmless, because that would be dependent upon how that all would have unfolded. And so with respect to Beavers, just a couple of points that I want to touch on with that. Really, the key issue in Beavers is when someone takes subsequent remedial action, sometime after the initial false statements were made, does that remedial action tell us anything about the state of mind of that person at the time the false statements were made? And that is something that Beavers noted could go one of two ways. It could be a genuine effort to correct a mistake. It could be an attempt to cover up purposeful wrongdoing. And so it's a case-by-case analysis that Beavers says the court has to undertake. And here, the facts and factors that would go into that analysis strongly support the district court's conclusion that that evidence was not relevant. And even more so, had it been, it was properly excludable under 403. That amendment was made after the IRS notified the defendant that it had discovered her almost $100,000 in omitted income. It was made a year and a half after the original false return was filed. And in addition, this was not a situation where the discrepancy was, possibly a typographical error, a zero missing or something like that. This was very clearly apparent from the face of the tax return, where she claimed total income of $11,533 and her true income was over $118,000. That was something she didn't need the IRS to put her on notice of. That was apparent from the return itself. And so none of the facts that kind of are in the ether about whether her later amendment would be relevant to her state of mind at the time of filing supports the conclusion that this would be relevant of good faith or relevant of mistake. It's in fact very much consistent with it being an attempt to cover up her wrongdoing. And the evidence of the falsities in that amendment just supports that all the more. So it makes the evidence less relevant and also more confusing. And the fact that had this been admitted into evidence, there would have been extended additional evidence presented about what types of what types of deductions are properly deductible. We would have needed the revenue agent to educate the jury on whether work clothes and cleaning of work clothes are properly deductible expenses. We would have.
I'm sorry to cut you off, but I see your time is short. So I take it the government's position is not that the government would concede that in some instances, if all we have is a person who receives a notice from the IRS and then they immediately correct their tax amendment, depending on the facts, that might come in as a remedial measure, or that might have some probative value with regard to the original intent. You're just arguing, given the facts of this case, it doesn't.
That's correct. Under Beavers, the analysis needs to be case by case. And so there are conceivably cases where there was a civil notice, for example, a prompt correction, and perhaps also the discrepancy between the original and the amended would make it seem more likely that there was an inadvertent error. That could be a situation where the subsequent amendment would satisfy the relevance and where there wouldn't be 403 issues that would independently be a basis for excluding the evidence.
And my guess is you would probably argue the number of times that a tax return had allegedly been falsely filed would be relevant there.
Yes, Your Honor. And in addition, the number of different falsities within a particular return would also be something that would be considerable for that as well.
Do you think that, getting back to kind of our original question or inquiry, do you think that if a court in making an evidentiary ruling prohibits a defendant from raising something as part of the defendant's case, that almost always raises constitutional issues? So for example, say in the hearsay context that I noted, or say on basis of relevance, or even 403, where a defendant wants to argue and present something that they think, you know, is that they believe is probative of their case. Would it always do so, or only in some circumstances?
Only in some circumstances. Beavers addresses this point, the fact that criminal defendants do not have an unfettered right to present any and all evidence that they want to present in disregard of the rules of evidence. Those rules apply equally to the government and to the defendant. And when, in light of those rules, the defendant has a situation where a defense that they want to present cannot in any way be presented, that may raise a constitutional issue. It may not. It may be a nullification type defense. I mean, there may be defenses that they don't have a right to bring forward. And so that's why I think it is a factual intensive inquiry as to whether there would be much that this court would need to do in terms of a de novo review of whether evidentiary rulings caused a constitutional issue to arise. If the court has no further questions, the government requests that the judgment and the sentence be affirmed.
I have one question. I want to move to sentencing. And
Yes.
as long as we're talking about standard of review today, address the standard of review for the sentencing argument. Is it the government's position that this objection, which was not raised at oral argument, should be reviewed for plain error, or does this fall within Rule 51, something that couldn't have been raised while the court was elaborating on the sentence? And how would you distinguish here?
The latter, I would say in this case, the way that the government distinguishes these based on this court's precedent is whether the defendant was on notice of the issue in advance of the sentencing hearing, had time to consider and formulate a position. And in this case, the sentence being pronounced of a year as opposed to a year and a day happened in the sentencing and didn't allow for advanced formulation of a position. So the de novo review, the government believes, is the appropriate standard, but I will note that the facts have changed on this a bit since the briefing. The defendant has, her term of incarceration with BOP has concluded. She was moved out of confinement in, I believe, May to a halfway house, and her confinement in the halfway house concluded in August. And so the government believes that the sentencing issue is now mooted because she is no longer in BOP custody.
Okay, thank you.
Thank you.
Ms. Gambino? We'll give you 2 minutes. And
Thank
if
you
you
so
could
much.
start with the sentencing issue, please. Do you believe this has been mooted?
I believe it would be, I don't believe it's been mooted until we know what your decision is with respect to the other issues. So, for instance, if you were to grant a new trial, as we request, then it might become relevant.
Well, it would certainly be mooted though, because if there's a new trial, any sentence is vacated and we start over, it would be kind of an advisory opinion at that point. wouldn't
That's
it?
true. It might, but I think it's a valuable opinion to have. So,
Let me ask you one more thing on sentencing, please. Are you appealing the sentence the court imposed or the denial of the motion to correct the sentence?
the denial of the motion to correct.
So you're not raising a procedural or substantive challenge to the sentence itself. It's the denial of the subsequent motion to correct the sentence from a year to a year and a day. That's what your appeal is.
Yes.
Okay, thank you.
And with respect to the issue that we dealt with originally, I think if there were only one evidentiary issue and no evidence in the record that Ms. Collins wanted to testify, that it might hold more persuasion. But there was evidence in the record that she did want to testify. And we had the court's reversal of its original pretrial ruling, allowing the government to cross-examine on unproven allegations. So I think it's a little bit more complicated here, in addition to the limitation of the expert. It's not just the Beavers issue that we're dealing with. So we would ask that the court reverse and remand for a new trial.
Thank you.
Thank you.
Thanks to both counsel. The court will take the case under advisement. Do we have all counsel? We do. Okay, we have all counsel present for what was our first case that we will go to now. So appeal numbers 24-1392, 1393, 1394, 1395, and 1960, Tischauser versus Mode Transportation LLC et al. Give you time to get settled.
May I ask, one of the counsel for this field is in your.
We have counsel remotely on
Is
the video. Yes, if you look up there at the screen, you can see him.
Good morning.
So, good morning. You have given us your proposed breakdown of how you want this appeal argued. Mr. Tooney, you're first on behalf of the appellants. You have 6 minutes, and then Mr. Lesbrance, you're on the video here. You go second with 2 minutes. So Mr. Tooney, I'm going to start with you. Whenever you're ready, come up to the podium, please, and we will give you 6 minutes, saving 2 for rebuttal. So watch your time. Mr. Tooney, are you ready, sir?
Yes, sir.
Come on up to the podium, please.
That's what we're calling for the case argument. I misunderstood. I'm sorry.
Ace will argue first for the defendants. So I'm following the order that you gave us. Good morning.
Good morning, and thank you for your patience with me. 40 years ago, when I came here, I didn't have Google Maps, and here it didn't help me today either.
And I will note that Mr. Leskrantz is on the phone, on the video. So go ahead, please.
Thank you, Your Honor. As you've seen through the plea or the brief that we filed, we are here to ask the court to reverse itself from the Yee decision. We are aware that there's a high mark that we have to achieve to justify that. I think we have that. The Hively case indicated that adjusting your jurisprudence to be in coordination with what the Supreme Court is saying was the reason justified for the using Hively to change the jurisprudence of this court. We think that same formula works here, in that all of the cases by the Supreme Court dealing with exceptions to making exceptions under the historic police powers of the states to having rights or claims wiped out. All of those, none of those cases was discussed in Yee. I think the problem that happened in Yee was citing Puerto Rico, which in one sentence stated that when there was an express preemption clause, the court should look to the language of the statute to interpret it. But
Mr.
there's
Tooney,
also case law.
So we reaffirmed Yee in Montgomery. and
Yes,
declined to revisit it. And I know there's a circuit split right now, and I think you would agree that the Supreme Court has never addressed the precise preemption issue before the court today, and that was before the court in Yee.
they have not addressed it like this, although they've discussed it.
There are two cert petitions pending before the Supreme Court now, one in our Montgomery case and one in the Sixth Circuit's recent decision in Cox, which came out the other way from us in Yee. Is there any reason that this court should hold off deciding your case until we get the guidance from the Supreme Court, or see if they're going to take the cases?
I would argue, yes, this court should enter its ruling simply because
So wait, the yes to my question was a little different. I want to make sure you understand the question. My question for you is, should we wait for the Supreme Court to see if they are going to grant the cert petitions? And if they do, wait to see how they come out? Or should we just decide this case?
I think you should just decide it. I
Why?
think it would be better for this court to correct what I think was a terrible error, rather than have it do it on reversal by the Supreme Court. The decisions of the Supreme Court never came up in Yee. I think that what happened with that one sentence in Puerto Rico saying that you should simply analyze the language of it, of the statute at issue. Puerto Rico did not discuss and did not even attempt to analyze why it should reverse anything in the jurisprudence concerning the police powers of the state being protected. The police powers of the state were not involved in Puerto Rico, which I imagine is the reason for the way they wrote that decision. But it's not as if the jurisprudence of the Supreme Court had stopped less than 2 years after the last case decided by the Supreme Court, where they used that power to say that the police powers of the state were to be garnered.
If you assume we don't overrule Yee, that there are some distinguishing facts here. You have a shipper that wasn't present in Yee. You have some claims that weren't precisely addressed in Yee. If we don't overrule Yee, where does that leave us on affirming the motion to dismiss?
If you do not overrule,
Correct.
well, I guess then we'll be looking to see what the Supreme Court does on these other cases. They've denied cert so far, I think 5 times on this issue. Perhaps the Cox case will be a reason why they finally decide they want to take it.
My question's a little different. I assume Yee remains good law.
I'm sorry?
Assume Yee remains good law, that
Yeah.
we don't overturn
Yeah.
it, that the Supreme Court doesn't disturb that core holding. Would you still be arguing that under Yee, there are some distinguishing factors, such as you have a shipper here as one of the defendants?
Well, you have a shipper, but there's a question about whether or not the trial court's ruling preventing an action against the shipper. There's a question about whether that's valid. The shipper could have potential liability through the broker if the broker has any liability.
You didn't differentiate between the shipper and the broker in your briefs. Do you agree that their liability rises and falls together? So if Yee applies to the broker, do you agree it also applies to the shipper?
I believe it does ride together.
You're into your rebuttal time if you want to save the remainder, Mr. Tooney.
No, I'd like to save my rebuttal.
Okay, thank you. Mr. L'Esperance, good morning. Can you hear us okay?
I can. Thank you, Your Honor, and I do appreciate Lee granting me remote appearance today. It's an honor to be in front of the court. I'm arguing primarily on the procedural issues here today, And it won't take long, but the primary concern I have here is if you affirm the district court decision, and assuming Yee was upheld and not addressed by the court, then you're effectively overturning your own case law on preemption in relation to when is it appropriate to bring a motion to dismiss. And this issue on preemption comes up about once or twice every decade, it looks like, on the court law, in the case law. And the court has been firm in that you cannot bring a motion, a 12b6 motion on a preemption defense because it has not been pled. And that's what happened
We
here.
also have law that says there's a narrow and pragmatic exception to that. And that's when raising the affirmative defense, you don't need to go through a 12C because it's apparent on the face of the complaint. Why wouldn't this affirmative defense, namely preemption, be apparent from the face of the complaint, especially in light of Yee and Montgomery?
That's a great question, Your Honor. And primarily because that case law deals with statute of limitations. When you look at the cases
But it
cited,
wasn't limited to statute of limitations. It addressed affirmative defenses,
yeah, and statute of limitations is an affirmative defense.
as is
And
preemption.
yes, but statute of limitations are different. You look at a statute of limitation case, the plaintiff should know what the dates are in terms of the incident or occurrence. And you shouldn't have to wait until the defendant anticipates that defense. Whereas when you have preemption, the plaintiff does not know that that defense will be pled. So we can't anticipate it. The case law is very clear. You cannot anticipate the defenses. You're not required to do it. So when you look at a statute of limitations case, the plaintiff should know the dates. And when they assert those dates in the complaint, it is highly credible for the court to rely upon in that regard. Here we have no facts or circumstances from the defense. They have not submitted any evidence in this case on what their case is related to their defense. They've just submitted argument. Briefs are not the pleadings. And so that's a very distinguishing argument. That's why I believe that case law is limited to statute of limitations cases. But generally speaking,
Why would it make a difference here? What do you think we would glean from a defendant's pleadings that would bear on this decision beyond what we can see from the complaint?
well, it does matter in terms of the plaintiff being able to contest the facts and circumstances. Here, the relationships. This case is important in terms of relationships. And so we would be able to conduct discovery to test that and confirm, do they have a broker license? Are they associated with motor carriers and whatnot? You could go into that and start contesting that evidence and say, no, preemption does not exist under XYZ law, here the FAAAA.
But presumably we could decide it on under the procedural rule that you advocate. We would be able to decide the issue, would you agree, as soon as an answer is filed?
Well, not necessarily as soon as it, but it does open the door then to, again, pursue discovery, at least request the district court. I guess the district court would have to take that into consideration. I can, my experience, I've never seen a 12C motion brought right after the answer is filed, but theoretically it is possible, but the plaintiff would have alternatives to respond. And unless the court has any other specific questions, I'll reserve the remainder of my argument for rebuttal.
Okay, thank you, Mr. Lesperance.
Thank you.
Mr. Wadley? And you are arguing on behalf of Ace Property?
I am, yes. Sir.
Okay.
May it please the court, Chris Wadley on behalf of Ace Property and Casualty Insurance Company. Your honors, our position in this case is that the district court erred by declining to apply subsection 2 of Wisconsin statute section 628.46 and instead holding Ace liable to pay interest on the full amount of Mr. Tischhauser's initial policy limit demand.
Mr. Wadley, can I? Go ahead, please.
Subsection 2 talks about not being able to obtain a release. You just wanted a release from every claimant. Isn't that a little different?
Well, subsection 2 talks about not knowing who is entitled to receive the payment. So there's 3 elements of the portion that we're relying on here. One is the carrier is unable to determine who is entitled to receive the payment. The carrier notifies the claimant of that inability and promises to pay upon resolution or determination of who's entitled. In this situation, all 3 of those elements are satisfied. We had 4 claimants, all involved, all severely injured in the same accident, 3 of whom had damages standing alone that exceeded the entire policy limit. Therefore, the carrier in this situation, my client was unable to determine who was quote unquote entitled to the policy proceeds.
Mr. Wadley, what are we then to make of the correspondence from your clients that basically said that ACE had the right to dispense payment to whichever one of the claimants had provided enough proof of special damages to merit them?
Well, that was certainly the position that my client took based on
And
the
so
case.
your client, and do you agree with that position?
Well, it's an argument based on the Loveland case that the direct action statute does not require a pro rata distribution. I don't know that there's a case that definitively establishes that as a matter of law under Wisconsin law.
I guess my question is a bit more direct than that. Do you agree or disagree with what your client said in that email?
I mean, I agree that in that situation, if ACE were to make a determination on itself as to how to allocate the proceeds in the best interest of its insureds, that would be appropriate under the circumstances. But the problem with that is that anytime you have a conflict of interest between an insured and the insurance carrier, where the insurance carrier controls the payment of the money, it could be subject to second guessing, especially if it leaves the insured exposed to additional liability. So you have a situation here where subsection 2 of the statute we think is plainly satisfied, given that there's no statute, there's no case, there's no Wisconsin law that says Mr. Tischhauser was entitled to the full policy limit just because he's the first one that
I
asked.
think you could have stopped after there's no Wisconsin law, period, on this particular provision.
Right.
There isn't one way or the other.
That's exactly right. Yeah, I mean, the cases that have interpreted this have said, okay, in a single claimant case where there's no question of liability and there's no question that the damages exceed the policy limit, in that case, the carrier cannot say, I'm not going to pay the policy limit unless you give my insured a release. So that's Wisconsin case law on that. But the case law does not interpret subsection 2, which is the situation that we have here, where you have 4 severely injured claimants, 3 of whom have damages that exceed the limit standing alone. And there's simply no case, statute, anything that says Mr. Tischhauser is entitled to the full $1 million simply because he demanded it first.
Are you disputing that your client had to pay any interest at all? Or is your argument that it should have paid interest pro rata?
Our argument is that it shouldn't have had to pay interest at all because
How did you satisfy the requirement that your client had to offer in good faith to promptly pay said claim upon determination of who is entitled to receive such payment?
So if you look at the correspondence that was issued, and I would refer to document 215-3 in the trial court record, and that's the email in which counsel for ACE and its insureds proposes 4 different methods by which the parties could agree on an allocation, and there's an offer to pay in there upon a determination. And those 4
is that you're waiting for the releases, not that you're offering to pay.
No, I would disagree with that, Your Honor. I think if you look at the emails, counsel is saying we would like releases as part of this negotiated settlement. But what we don't have is a situation here where the 4 claimants said, okay, we agree, this is how the $1 million should be split up. There's no dispute entitlement is satisfied, pay that, but we're not going to give your insureds a release. And if that was the situation, and if A said, okay, we've all agreed on how the money should be split up, but we're not going to pay it unless we get releases for our insureds, then you would be in the conduits area where that would be not a defense to owing interest. But we had a situation here where the claimants would not agree amongst themselves, excuse me, how to divvy up that money. And what ACE is saying is that, okay, well, as part of the process of figuring this out, we would like to get releases. And in fact, if you look at 215-8, I believe the document is, counsel says, excuse me, I'll find it here. He basically says, look, I'm going to ask for releases. If it's in the cards, I would like releases for my insureds. But nowhere does he
It's a
say,
little bit stronger than in 215-13. He said, look, there's $1 million policy. It's already down to about 999,000. And the longer it takes to agree, essentially, you're not going to have it to agree and to complete the releases and hold harmless.
and again, Your Honor, there's nothing wrong with asking for a release as part of this process.
I agree, there's nothing wrong with that, and it makes good business sense for your client, but that's not what the language of this is about. This is about paying interest, but you have to make a good faith offer to promptly pay. So two separate issues.
Well, I think we did satisfy that. I think we did satisfy that by the correspondence that said we will pay if there's a determination as to who is entitled to what portion of the proceeds. And there were 4 different methodologies that were presented as a way to get there. Now, if that had been resolved and A said, we're still not going to pay you until we get, until we get releases, that would be an entirely different situation. But unless and until that initial determination of who's entitled to the proceeds, subsection 2 kicks in and interest does not accrue.
But I thought your client had stated that Mr. Tischhauser has already submitted a written settlement demand with sufficient supporting documentation demanding payment of the remaining available limit. So it's not that the insurer, it's not like your client wasn't able to determine that he was entitled to it. You're saying that your client wasn't able to determine who else might have been entitled to it. But the thing is, at a minimum, your client, Mr. Tischhauser, provided sufficient information. I don't think there's any dispute about that. And that information indicated that he would probably exhaust the remaining limits, available limits. And at that point, it seems as though the Wisconsin Supreme Court's decision in Kantowitz kind of kicks in. And, we're not talking about whether or not the insurer has to, satisfy some metaphysical certainty as to how everything should work out. I mean, from the language of statute, it seems like, boom, when the insurer knows and is able to determine, which your client claims it was, proceeds should be released.
So that presumes that Mr. Tischhauser was entitled to 100% of the policy limit simply because he made the first demand. And there's not any case law that says just because he's the first one that got a lawyer and issued a demand means he's entitled to 100% of the proceeds. ACE was fully aware of the fact that there were 4 injured claimants and that they all had suffered severe injuries. So, I mean, if that's the nature of Wisconsin law is that we want to reward the first one to issue one of those demand letters, then I suppose so be it. But that may be a reason to certify the question to the Wisconsin Supreme Court. We don't think that that's good public policy. We don't think that's an appropriate resolution because that leaves the other 3 injured claimants completely without any insurance recovery. It leaves the insured without any insurance proceeds to defend or indemnify with respect to those remaining 3 claims. So yes, we were aware that a demand had been made. We were aware that Mr. Tischhauser's injuries were sufficient to justify payment of the policy limit. But what distinguishes this case from Kantowitz is that we had 3 other claimants that were also injured. 3 of whom also, 2 other ones also had injuries that by themselves exceeded the policy limit.
Okay, thank you, Mr.
Thank you.
Wadley. Mr. Kuzmanovic?
Thank you, Your Honor. Good morning. Very pleased the court. I'm here on behalf of Mode. Mode was, Yee was decided in 2023. Montgomery was decided this year. Judge St. Eve, you are well aware, having been on both of those panels. I've heard these arguments before. It's our position that the negligent hiring, negligent selection claim has been properly dismissed because the F4A preempts that.
Mr. Kuzmanovic, could your client ever be liable for negligent hiring? I know there were various theories of liability, joint venture, otherwise here, and you're arguing preemption should apply to all of them. But is there any theory under which your client could be liable?
I have not seen any case that would allow for that in terms of what the facts that have been.
Even the extreme, even if your client hired somebody or was the broker for a company that it knew had the worst drivers with the worst record, who had DUIs. I mean, come up with the scenario.
I'm sure theoretically, Judge, that there is a scenario in which somebody could try to pierce that, but at least as far as the facts that have been pled in this case and the facts that we've seen both in Yee and Montgomery, I don't see that. It's in the Seventh Circuit, and I think what we look at here from the standpoint of preemption, in this particular case, we've got the negligent selection. We also have the agency and joint venture claims, which are also negligence claims, which Judge Griesbach also dismissed, and which we agree with, obviously, entirely. Then we've got the alternative methodology that the judge used for failure to state a claim under Iqbal for the other individually pled negligence claims. So in our view, Judge Griesbach properly decided first the negligence claims based on Yee, and I'm looking at the Yee case language at page 459. By recognizing common law negligence claims, courts would impose in the name of state law a new and clear duty of care on brokers. Well, we have that's what these other two claims are: the joint venture claim and the agency claim. And if you look at what Judge Griesbach did in analyzing those claims and going through the complaint and looking at whether they were even well pled, even Judge Griesbach found that as an alternative method to getting the case dismissed, those claims were not pled well.
What's your position on whether or not we should wait and see if the Supreme Court grants cert in either Montgomery or the Cox case?
Our position is that the court should not wait. It's good law. It's in this circuit, and there are two cases that have held that the F4A preempts negligence claims against brokers. So it's our position that the court should not wait.
If I could ask, so I take it that if the plaintiffs had brought a negligence claim against the driver's employer, Firebird, that claim would likely survive preemption.
Yes.
Okay.
And I think it did, Judge.
And so then if there is alleged some sort of joint venture or agency theory, and I understand you take issue with whether something was sufficiently pled here, but assume that that the plaintiffs could allege that Mode and even Cisco directly was able to dictate the working environment, the working restrictions, and had someone on site that was supervising Firebird's drivers. In that kind of factual scenario, would you agree with me that a vicarious liability claim or even a joint venture claim might survive preemption because it's basically, there's nothing to really distinguish that from a direct negligence claim against the employer?
I think, Judge, it all boils down to control, whether that control is adequately pled, number one. And for the joint venture theory, you have to share profit.
No, I understand. But if we assume that for current purposes, that those claims were adequately pled, then you would agree that we have a much closer call.
I think so, Judge. I do agree. But our position is that A, they weren't properly pled, and B, in this fact scenario, we're so far down the line here. Mode hired Donnelly. And Donnelly subcontracted to someone else who who then further had their own driver. So we are way down the stream here.
I understand. Thank you.
Thank you, Your Honors.
Thank you. Mr. Temple?
Good morning, may it please the court. James Temple on behalf of Cisco Corporation. And to echo my colleagues' comments, we believe that the district court properly dismissed all complaints pending against Cisco under both preemption and 12b6, no plausible claim. We believe that under the analysis of Roe, as well as under the analysis of Yee, preemption was properly applied to bar the tort claims pending against Cisco Corporation. Cisco Corporation is a shipper in this case. Cisco had an agreement, a separate standalone agreement with Mode to broker loads. Mode then would go out and find motor carriers to ship the loads. In this case, that was Donnelly. Donnelly then found another motor carrier who had a driver to ship the load at issue. And as the district court pointed out, the driver never actually got the load to pick up from Cisco. So in this case, from a plausibility standpoint, based upon the allegations in all of the complaints, there is no plausible theory under those allegations by which Cisco could ever be connected to the negligent actions of a driver under the allegations of these complaints, and was promptly dismissed on a 12b6 basis. The joint venture claims, as Judge Lee just pointed out, were not properly pled, although the allegations were incorporated into that count. So you have a count that alleges desperate treatment does not have a common contract, does not have a common purpose, and does not have sharing of profits to meet the basic elements of a joint venture. So that was properly dismissed on plausibility basis. Going back to preemption under Roe, I think Roe stands for the possibility that the effect of these regulatory laws, and as we all know, common law is regulatory law. If that's affecting the price, routes, and services of a broker, then it's preempted. So I don't think there is a scenario where you can find a tort law being applied to a shipper that would not be preempted by federal law. I don't think this court needs to revisit its decisions in Yee or Montgomery based upon what has already been pled or argued. The decisions in Yee in Montgomery look towards the totality of the preemption statute, and you have a federal regulatory scheme that protects brokers, in my case, the shipper, from these tort claims to regulate interstate commerce.
What's your position on waiting for the Supreme Court to see if it grants cert in Montgomery or Cox?
I don't think this court needs to wait on whether or not the Supreme Court grants cert, because from Cisco's position, our position is unique and there's not in those cases, Your Honor. So we would ask for a ruling on the issues. And if there's no further questions, I thank the court for its time.
Thank you. Mr. Tooney, you have a little bit of rebuttal time left.
Just a couple of comments, Your Honor. The section 145.01 sub 1 sub C, the preemption clause does not itself say brokers are to be preempted. It's left unsaid. So we think there's an actual issue here, as if the clause is susceptible to more than one plausible reading, courts generally, ordinarily accept the reading that disfavors preemption. Second thing was that the second clause, 14501 C2A, didn't list the word brokers in it. And that was something that the E case mentioned as thinking that this was intentional by Congress. But it also, that same statute did not include any of the other parties listed in the preemption clause. In other words, they left it open so that any person would have liability under that clause if if the facts justified that.
Thank you, Mr. Tooney.
So
Time's up. Thank you. Mr. Lesperance?
Thank you, Your Honor. Use the time to respond to ACE's arguments, as my client is the only client that's in both appeals, two separate judgments. There was some arguments being made regarding, there's no case law for the first person to write a demand to get the policy proceeds. There was also reference to, second guessing fiduciary duties, and it's bad policy. This is a statutory right. This is a statutory right created by the Wisconsin Assembly. That's not for this court or the Wisconsin Supreme Court to modify. That is a decision made by the people of Wisconsin through their representatives. So that should not be modified on those grounds. Additionally, there's constant reference to 4 claimants, but the record is very clear that only one demand was made. The 3 other claimants never made a demand at any point in time. The court should not base its ruling on theoretical facts. This is not a case where 4 demands were made at the same time. This is not a case of 4 demands being made within 30 days of each other. Those are different circumstances and different facts. This is one claimant who made a demand, who the insurer acknowledged was entitled to payment based on the facts provided in proof of claim, and yet the insurer did not pay. They can have any type of equitable distribution they want within that 30 days. They can try to resolve it with the 4 of them. But once that 30 days hits, payment is due. If it is not paid, then interest is made. Interest is compensable. It's not punitive. This is just like any other sort of common law right for interest, like in a contract case. That's all the Wisconsin Assembly's done here. And ACE made a choice. It wanted the release, and it wanted it really bad, and it wanted it from all 4 of them. And it chose to not pay the claim, to hold out and get the settlement release. And under Wisconsin law and contivence, which this case is held by, and the court correctly ruled upon, my client is entitled to interest on that because he made a proper demand. All those elements were satisfied. Subdivision 2, there's constant reference about who is entitled to receive such payment. There's no reference to how much. Looking at the actual provision in subdivision 2, it states who is entitled to payment. ACE knew who was entitled to payment, Tisher. Second of all, it knew who the other claimants were. All 4 of them were in the same vehicle. There's no dispute here. So to argue they didn't know who was entitled to the payment is baseless. They knew who it was. They just didn't want to make any specific determination on amounts. So unless the court has any questions, we just request that the court affirm the decision in the Tischhauser v. ACE matter and reverse the district court in the Tischhauser versus Mode versus Cisco. Thank you.
Thank you. Thanks to all counsel. The court will take the case under advisement. And we are going to take about a 10-minute break, and we'll pick up with case number 3 when we're back.
Thank you.
We have some of that. That was right. Yeah.
See what the tea leaves show on.
And these are Is this about, I don't know,
This honorable court is now in session. Please be seated and come to order.
Our next case for oral argument this morning is appeal number 24-2799, Zemlich versus Burkhart. Mr. Ellis, whenever you're ready, please. Morning.
Morning, Your Honor. May it please the court. Nicholas Zemlich is here in connection with a colostomy takedown that he had while he was a pretrial detainee at Hancock County Jail. That's simply a procedure where he had previously had a colostomy bag. Creates a cavity into the colon. The goal is to reverse that so he can have regular bowel function. So he was returned to the Hancock County Jail December 13th. Over the course of the next 13 or so days, he developed a very serious infection that led to him being rehospitalized with possible sepsis. There are some photographs along the way showing how gruesome that infection progressed over time. There are two individual defendants that we are pursuing on appeal. One is the assistant jail commander, Matthew Boots. He had an office that was across from the cell in which Mr. Zemlich had been held during that recovery period. During that period of time, Mr. Zemlich was talking with Lieutenant Boots every day that he was there, which is at least 7 of the days, the 13 days as that infection progressed. It's undisputed that Mr. Zemlich had complained that he was receiving inadequate care with regards to his wound. Whether or not Mr. Boots was able to make his own independent evaluation. He
So what
certainly,
evidence is there about the specifics that Mr. Zemlich allegedly said to Boots? Because I looked through the record, and while even your client testified that he made some general grumblings or general complaints, I didn't see anything with any kind of specificity that would have put Boots on notice about his particular complaints.
I think the record does not contain specific statements to the extent of, I told Lieutenant Boots on December 16th that my wounds weren't getting changed. Instead, what
I mean, with the date specificity, but I didn't see anything that Boots said, oh yes, I told him that Nurse Holmes was not caring for my wound. I told him that the infection was getting worse. I didn't see anything other than just general statements that, oh, I wasn't happy with the care.
Mr. Zemlich was complaining that he wasn't receiving the care that was ordered. And if the court were to review the medical records, you'd see there's only 5 charts, I believe, that occurred over the course of that 13-day period. Not all of the care that was ordered was being
But here's my
provided.
concern as to Boots, that under the law and for deliberate indifference, he had to be on notice.
At the same time, Your Honor, as
And he didn't have an obligation to go look at the medical records to put him on notice. So your argument has been that Mr. Zemlich put him on notice. And just to focus you in on where my concern is, I don't see specificity in the record as to Boots of putting him on notice about the particular medical concerns that your client had.
I think it's accurate, Your Honor, to say there's nothing specific in the record whereby Mr. Zemlich said, I was not receiving every single wound change that I was ordered to receive, or that I wasn't receiving the pain medication. That is not in the record.
Or that my wounds are infected and they're not getting care. I mean, even something more general like that, it was, his testimony was, I told him I wasn't happy with care, period.
Well, he told him that he told him what was going on every day as it happened. And Mr. Zemlich did testify about the things that were happening along the course of his worsening infection, including becoming gray and clammy, having pain, having discharge from his pores and from the wound. Some of these things may well have been invisible to Lieutenant Boots. Other things are going to have been visible to him, including these last several days when Mr. Zemlich was not able to get up and move around because he was in so much pain and his coloration had changed. These are things that would be obviously apparent to any layperson that Mr. Zemlich was doing worse over the course of that 2-week period. And it's undisputed. The district court agreed, opposing parties agreed that there were complaints made. And for the purposes of due process for jail staff, it's not particularly important what they know about the condition because they're not themselves able to make medical determinations. The purpose of—
But it is important in a deliberate indifference as to medical care, where you have medical staff at the jail that the officer knows is daily seeing the client. So I would agree with your maybe initial statement as to due process, but on the specifics of a claim like this, I think it is important, and our case law says that.
Well, I think that between the fact that it's undisputed that he had complained about the care he was receiving, and it's physically obvious, even if his wounds couldn't be seen, that any person who would be hearing from Mr. Zemlich about his worsening condition and actually observing his worsening condition, the wounds themselves notwithstanding, would know this isn't just a person grumbling about not receiving aspirin. There's something happening here. And the action that's required of Lieutenant Boots and other jail officers is not to determine whether or not appropriate medical care is being given. but simply to take the complaint from the detainee to medical staff and receive some kind of verification that appropriate care has been provided or that appropriate care will be provided. It's an extremely low burden on the part of the jail staff. And I want to be clear, Mr. Zemlich is not arguing that Lieutenant Boots would have had any obligation to, hear back from medical staff and then be able to make a determination about whether their judgment is correct. There are cases that the court has heard before, such as Miranda and Greeno, in which jail officers simply go to medical, relay the concern, receive assurances that care will be given, and they have discharged their duty. And that's may well have been all that Lieutenant Boots had to do in this case.
With regard to Lieutenant Boots, you are challenging his kind of conduct or his knowledge after the first surgery. Do you have any claims against Mr. Boots with regard to any actions or inactions after the second surgery?
Your Honor, in earlier stages of the case, there were live claims that related to that post second surgery period. For the purposes of this appeal, we are really focused on these 13 days after the first surgery and the rehospitalization. So the other issue here that was overlooked by the district court with regards to Lieutenant Boots is in citing to the Spencer case, there was an extensive record that had been generated. And this is the source of this criticism as to specificity. And in that case, the plaintiff had a relatively minor medical condition, had submitted complaints over a period of several months, and they hadn't been properly addressed. In Mr. Zemlich's case, that simply wasn't a possible course of action. Over the course of 13 days, he went from a fresh surgery to possible sepsis. He was in a cell where he didn't have access to these medical kiosks. So he wasn't able to submit a healthcare request form like he might have been able to do in other contexts. He's solely dependent on jail officers responding to him when he complains, and also medical staff providing appropriate care. With regards to Corporal Schmidt, he was the officer in charge on December 26th, the time that Mr. Zemlich was ultimately returned to the hospital. Corporal Schmidt had an obligation to do something to immediately return.
But didn't Nurse Holmes indicate to Schmidt that the transport could be scheduled?
That is her testimony. Mr. Zemlich's testimony about that exchange is that she told Corporal Schmidt that Mr. Zemlich had to be returned to the hospital or he was going to die. So there's inconsistent testimony. It's entirely possible that a jury would hear from Mr. Zemlich and hear from the nurse and make a credibility determination that indeed that was the course of events. But at the time that she was giving that testimony, she herself was a defendant. In this dispute, the court's going to have to resolve it in favor of Mr. Zemlich. His version of events is the one that exists on appeal.
I didn't see you disputing that particular fact, though, that Judge Kohler just raised. I know you raised the argument that she said he has to go to the hospital or he's going to die. But she did testify, and it was in the 56.1s, that he could go by regular transport. And I didn't see that fact disputed.
It's the testimony that Mr. Zemlich gave. It should be treated as inclusive of that entire encounter, which is Mr. Zemlich was taken out by the nurse. They told Corporal Schmidt that Mr. Zemlich needed to urgently be returned to the hospital or face death, and then was sent back to the cell. So to the extent that the nurse is given inconsistent testimony, and it's not entirely clear whether or not that actually was said at some other point in time, that's additional facts that would need to be developed at trial. The court shouldn't simply assume that one can slide that fact in light of Mr. Zemlich's testimony about what happened in that encounter.
Do you have a hearsay problem with regard to what Nurse Holmes said she told to Schmidt that she relayed to Mr. Zemlick?
No, Your Honor. In the first instance, it's an untimely argument that was raised on appeal by the appellee. But setting that aside, there are numerous potential exceptions, including a present sense impression that would overcome a hearsay objection. But more importantly, at the end of the day, it's not about whether or not it's true that Mr. Zemlick was actually going to die if he didn't go to the hospital. The purpose of that information is to show what did Corporal Schmidt know when he was making a decision about whether to summon immediate aid or send him back to the cell. And what Corporal Schmidt knew was there was a nurse saying that he would die if he didn't go to the hospital.
Just to clarify too, you are not pursuing an individual claim against the sheriff, correct?
No, Your Honor, we're not pursuing that on appeal. So when
And you are into your rebuttal time, just in case you care.
I'll reserve my time.
All right.
Thank you, Your Honor.
Thank you. Mr. Wilfond? Good morning.
Good morning. May it please the court, Adam Wilfond for the appellees, Hancock County Sheriff Brad Burkhart, Matt Boots, and Luke Schmidt. This court should affirm the district court summary judgment order. Because the district court focused on the merits, this morning I'd like to emphasize 3 alternative and narrower grounds for this court to affirm. First is Officer Boots's non-liability under Supreme Court and circuit case law. Second is the officer's entitlement to qualified immunity, even if this court disagrees with the district court's decisions on the merits. And third is Mr. Zemlick's Monell claims are waived, both for failing to respond to the appellee's argument on this point in his reply brief and for failing to comply with the district court's case management plan. So first, I'd like to talk about Officer Boots's non-liability under Ashcroft versus Iqbal and this court's decision in Burks versus Ramish. Section 1983 liability is personal, can't be vicarious. So a defendant is responsible for their own actions, but not for what someone else does or fails to do. And a consequence of this rule is spelled out in cases like Ashcroft versus Iqbal, this court's decision in Burks, and also Estate of Miller versus Marbury, which all hold that inaction following the receipt of a complaint about someone else's conduct cannot be a source of liability. And that's the entire basis of Mr. Zemlick's claims against Officer Boots. Mr. Zemlick complained to Boots about the medical staff's apparent failure to follow the treatment plan, and Boots essentially brushed it off and let Mr. Zemlick address those complaints with the medical staff directly. Mr. Zemlick wants to impose vicarious liability essentially on Officer Boots for the medical staff's misdeeds. But if the Supreme Court found in Ashcroft versus Iqbal that Attorney General John Ashcroft had no responsibility for remedying the harsh conditions of confinement or the unconstitutional acts of subordinates, it's hard to see how Matt Boots, as a county jail officer, would have any greater obligation to investigate Mr. Zemlick's complaints. Mr. Zemlick's argument that Boots had a duty to respond brings his complaints, brings his claim within the scope of Burks and Iqbal, and that's exactly what this court held in the State of Miller. And despite—
But we also have a line of cases in the jail setting that generally an officer can rely on the medical treatment, but you can't turn a blind eye to an inmate in distress or to obvious incompetence on the part of the medical staff.
Sure. Yeah, and I think here, Your Honor, there's been instances where far more egregious circumstances where this court has upheld that reliance on the deference to medical staff. For example, in King versus Kramer, more recently in McGee versus Parsano. And as you alluded to, there has to be either actual knowledge or reason to know. But if given these circumstances where Mr. Zemlich was housed essentially in the medical wing, in the medical unit of the jail, he's got medical eyes on him at least twice a day. He's well positioned to receive care. The Nurse Holmes testified, and Mr. Zemlich testified too, that anytime Nurse Holmes worked, she changed those bandages. There's the deference that Officer Boots is entitled to there. So along those lines of cases that we were talking about in Burks, they're not just limited to grievance officers or complaint examiners. In, for example, Arnett versus Webster, the jail guard knew the plaintiff wasn't receiving care, getting his medication. In a state of Miller, the jail guard knew that the plaintiff's brain tumor and lower bunk assignment. And most recently in Adams versus Regal, the director of investigation knew about the plaintiff's incorrect housing restrictions. And in Adams, this court said, I'm going to quote here, Burks rejects the notion that just because a jail officer is on notice of a constitutional violation, he necessarily has a duty to respond and may be held liable if he does not, regardless of whether those conditions are within his purview. So in all of these cases, this court refused to engraft liability onto a defendant for a third party's misconduct, even when the defendant knew about the underlying wrong. And so what these cases show is that the defendant must have not only knowledge, but also a responsibility to cure not the complaint, but the underlying issue. And relevant to Mr. Zemlich's claims against Officer Boots, this court in Burks said that a layperson's failure to tell the medical staff how to do its job cannot be deliberate indifference. So Burks and its progeny give this court a straightforward path to affirm summary judgment for Officer Boots without getting bogged down in the merits or qualified immunity. And I think that's also a good segue to discuss why Mr. Zemlich has failed to rebut Officer Boots's qualified immunity defense. Mr. Zemlich defines the clearly established right as the right to receive verification of complaints that he was receiving adequate care. But as we just discussed in cases like Burks, Estate of Miller, Arnett, Adams, and even Iqbal hold exactly the opposite. In Perez versus Finoglio, a case that Mr. Zemlich cites, that was an Eighth Amendment case decided on a motion to dismiss posture. There, the plaintiff had an open and obvious gaping hand wound. He wasn't receiving any medical care. He had filed grievances. Unlike here, he wasn't housed in the medical wing of the jail. And we're talking about a delay of almost a year in getting the plaintiff there to a specialist. And there was no claim or discussion in that case that there was any deference to medical staff because there wasn't any medical treatment to begin with. Mr. Zemlich also cites Dixon versus Godinez. That's an Eighth Amendment case about the conditions of cold and freezing cell temperatures. Again, no mention there in that case about medical treatment or deference to medical staff. The other three cases he mentions are Miranda versus County of Lake, Greeno versus Daly, and Arnett versus Webster. And so those were actually all decisions on the merits for county defendants. Qualified immunity wasn't even addressed. And I mention that because this court has openly questioned where a case is resolved on the merits for a defendant official, whether that could establish whether a right was clearly established in another case. So at the very least, the case of the Zemlich cites compared to the Iqbal and the Burks progeny show that there isn't a clearly established right, and that's why Officer Boots is entitled to qualified immunity. I'd like to move on to qualified immunity inquiry for Officer Schmidt, if I could. There, Mr. Zemlich frames the clearly established right as the right to receive prompt medical care for a serious infection. Well, that is far too general of a formulation under the Supreme Court in this circuit's precedents. But in the cases that Zemlich cites do not squarely govern the circumstances here. In Gill versus Reed, a case that Mr. Zemlich relies on, the defendant was a prison doctor who who refused to provide the prescribed medication. In Lewis versus McLean, this court reversed summary judgment, finding that a reasonable jury could find a correctional officer in the face of a debilitating and immobilizing pain that an inmate received or had been experiencing, found that it could have been deliberate indifference and remanded the case for a jury. But Lewis is pretty distinguishable here, I believe, because there wasn't any sort of reliance on medical staff or deference to medical staff like there was here. The medical condition was far more obvious. You know, it wasn't a case where, as Mr. Zemlich was experiencing here, he had an infection on his stomach, but it was obscured by bandages and that sort of thing. And then finally, in Goodloe versus Sood, the court said inexplicable delays in responding to an inmate's serious medical condition can be deliberate indifference. Well, there was a 3-month delay in that case. We're not talking about an hour and a half like it was here. And it wasn't inexplicable. It was due to the end of a shift change. So for those reasons, we don't believe that the cases that Mr. Zemlich cited can overcome his burden in Officer Schmidt's entitlement to qualified immunity.
What are we to make of Mr. Zemlich's testimony with regard to what he was told by Nurse Holmes that she told Corporal Schmidt?
Sure, Your Honor. Yeah, there I don't think there is any sort of factual dispute. We've raised an issue obviously in our brief, but even if the court disagrees with that it isn't hearsay, we will accept it for purposes of appeal that she actually said that, but that has to be viewed in the context of what else she said. We can't just cherry pick that statement. I mean, she said unequivocally in her deposition testimony that transport by county vehicle was sufficient, that Mr. Zemlich's situation was not emergent. He wasn't in, dire circumstances. And so transport by county vehicle was sufficient. And if there was
contradictory, that on the one hand, Nurse Holmes would say that if he's taken to hospital, he's going to die right now, versus, oh, you know what, we can just transport him in the ordinary course.
Well, it's tough to know what he did actually say. I mean, he didn't say that she said right now. He essentially, the way he has framed it, you've got to get him to a hospital or else he'll die. Now that, that might be contradictory or might be puzzling, I guess, in light of the other Nurse Holmes' other testimony. But I think that's all the more reason to allow, at minimum, qualified immunity, because there was some of that conflicting information. And if it, as we mentioned in our brief, Your Honor, if it was truly emergent, you would expect Nurse Holmes to raise some sort of issue or objection when Officer Schmidt apparently said, well, he can, shift changes in an hour and a half or 2 hours, he can wait in the cell until then. There's no evidence that she did that. And there's no evidence that Officer Schmidt called an ambulance like he would have if the situation was emergent. And Nurse Holmes herself could have also called an ambulance, but she opted not to. The last thing I'd like to address this morning is Mr. Zemlich's Monell claim. Now here we believe there's a case of double waiver. The first is because Mr. Zemlich's reply brief did not address the appellee's argument that he failed to comply with the district court's case management plan by including the Monell failure to train claim in his statement of claims. And so that amounts to waiver. Time and again, this court has said that an appellant's failure to respond to an appellee's argument in the appellant's reply brief amounts to waiver. But even putting that aside and looking at the kind of the second layer of the waiver here, which is the merits of our argument on this Monell issue, his failure to include that statement of, the failure to train claim in his statement of claims means that claim was either abandoned, waived, or forfeited. And like many district courts in the country, the Southern District of Indiana has a case management plan which requires plaintiffs to submit a specific list of claims to clarify the issues as summary judgment and trial approach. But in Mr. Zemlich's statement of claims, there really wasn't any mention of any failure to train claim. And there's
Is
countless.
that inconsistent with our law that says even if a claim or a theory is not specifically pled, as long as you're on notice of it, there's no prejudice to allowing you to amend your complaint? Or is that inconsistent with Rule 8's plain statement directive?
Well, Your Honor, I think there's, I think, two responses to that. The first is that this court gives the district court decisions on these issues considerable weight.
Not if they conflict with the federal rules.
I'm sorry?
Not if they conflict with the federal
Sure.
rules. That's my concern.
Right. And so we had, went on summary judgment, we had, and then basically taken Zemlich at his word that based on his statement of claims, he wasn't raising a failure to train claim. And we said, regardless, even if he is, here's all the reasons why it fails. And if Mr. Zemlich truly felt that he didn't get a fair shake at responding to that argument, he certainly could have moved for leave to file a surreply or, you know, get the last word on it because we had raised that issue. So for those reasons, we respectfully request this court affirm the district court's summary judgment order. Thank you for your time.
Thank you. Mr. Ellis, you have a little bit of time left for rebuttal.
Thank you, Your Honor. So I think the most important thing to respond to here is this discussion about deferring to and relying on medical staff. It is a significant feature of Apple's brief. As far as we have been able to determine, there's not any evidence that Lieutenant Boots had knowledge of the care that Mr. Zemlich was receiving to be able to rely. All we have is his knowledge that there were medical staff, and Mr. Zemlich then was complaining that he was not receiving adequate care. So at that point in time, his obligation became go to the medical staff and find out, is indeed Mr. Zemlich receiving adequate care? That's all that would need to be done. The rule that Apple is urging is that people like the Lieutenant Boots, who are much different than the Attorney General, who is not sitting across from Iqbal in his cell, when people like that learn that there's an issue, they simply have to do nothing if they have any notion that there's medical care being provided. And that's going to put people like Mr. Zemlich, who have no way to submit a healthcare request form on their own, in a lot of danger. So if appellees can actually identify some form of reliance, perhaps that would change, but through all of the briefing, it's simply asserted without evidence. In terms of qualified immunity, we did address qualified immunity both in the district court and in our reply brief on appeal. Our appellant's initial brief lays out quite significantly the governing case law, both as to Lieutenant Boots's failure to respond to Mr. Zemlich's complaints, as well as the test that this court has enunciated for dealing with claims of delay in providing medical care. Every case is going to be different, but the courts, through their case law, have identified that there are boundaries on these claims in a way that would put people like Lieutenant Boots and Corporal Schmidt on notice. With regards to Manel, we have identified in our brief, why we believe Mr. Zemlich properly pleaded his claims and included additional information about the discovery process, why Mr. Zemlich's asserting in his statement of claims that the county had failed to properly staff the jail. That should encompass the issues relating to training as well as quantity of officers. Thank you, Your Honor.
Thank you, Mr. Ellis. Thanks to both counsel. The court will take the case under advisement. The next case for oral argument this morning is appeal number 24-2166, Jones, versus Das. Morning, Mr. Stein.
Good morning, Your Honors. May it please the court. My name is Gil Stein, and I am court-appointed counsel for appellant Tonette Jones in this matter. In a nutshell, Your Honors, the district court's decision that is up on appeal here today should be reversed because our case turns on questions concerning the merits and motivations behind some alleged performance failures that the appellees cited to fire Ms. Jones. Consider 4 examples out of a litany of some 10 different ones that are in the record. Why was Ms. Jones fired for calling her supervisor a racist when her accuser recanted that same accusation as coerced by officers under the appellee's command? Why was Ms. Jones in fact insubordinate when she refused to tell a court that it had a trafficking report, a sex trafficking report, that Ms. Jones believed the court did not in fact have? Did Ms. Jones exceed her authority when she accurately warned juveniles about the consequences of not meeting with their probation officers? And then we have the question of, did Ms. Jones violate a disputed no child in the office policy just because she removed her son from the building's public lobby? Now, if the court is wondering how a jury might infer racism from the accusations against Jones, the answer to that question can be found in at least 2 facts that are undisputed. First, none of Ms. Jones's comparators were disciplined after they engaged in some of the same behaviors that Ms. Jones did. And second, Apeli Avik Das, who importantly, the court should note, is the senior most officer in the department, I believe his title was that of director, openly used the N-word in front of Ms. Jones's Black colleagues. Now, I want to stress, that is not the sum total of our case. And I understand that it wasn't said directly to Jones and that she heard about it secondhand. That is not the sum total of our case, but our point is that the district court did not consider that fact along with the others by giving it the weight that it should deserve. What happened here is when the district court was faced with jury questions at summary judgment, it improperly weighed only some of the evidence, specifically 3 of the 10 different incidents at issue, before it discounted Apeli's misbehavior as, and I quote, short-tempered, offhand, or isolated incidents that did not prove a race-based hostile work environment. I want to stress the word prove. That is a direct quote out of district court's decision. As this court's holdings in cases like Hall v. City of Chicago and the Johnson versus Advocate Healthcare Center make clear, Ms. Jones did not have to prove her claims at summary judgment. What she had to do is offer sufficient evidence of her claims based on all reasonable inferences from the totality of the circumstances. This is the controlling standard at summary judgment, and this standard demonstrates that the district court erred here. When our record is viewed in its totality, a reasonable jury could at the very least infer that racial animus motivated Jones's termination after her workplace was altered by her supervisors, as she says, baseless and humiliating accusations.
Mr. Stein, you mentioned comparator. Can you go through the comparators that you believe would give rise to an inference of race-based decision-making?
Yes. And let me preface my answer by saying it's not just the actual comparators that I will tell you about that we rely on for the race-based decision-making. But let me start with the 2 comparators. For example, there were officers Grunauer and Petla that are discussed, who there's evidence to show that they engaged in what we think is more serious misconduct than Ms. Jones. And they suffered very minor and no discipline, specifically between those 2 officers, and forgive me for not remembering which one of them did what, but there was falsification of workload records, and there were records that were never even processed at all. So I don't know if it was laziness or just work that was not done for quite some time, which put the juveniles affected on those files at risk and of prolonged incarceration that may have been unnecessary.
And I believe that Ms. Jones discusses them in her declaration on paragraph CA7 clean, do we have any other evidentiary basis to make that comparison other than her declaration?
Yes, so with respect to other comparators, there is Ms. Jones' testimony, of course, which by itself should suffice to create a question of fact about how other African Americans were treated less favorably than non-African Americans in the department. And we can talk about Jason Smith's declaration in a moment, but that's corroborated also by Jason Smith. My point is, even if we throw out the Smith declaration, Ms. Jones's statements create the disputed question of fact about whether others in the department were treated less favorably, others who also happen to be, of course, Black probation officers.
From that, you're referencing what Ms. Jones relayed about when African American employees would have conversations with various supervisors, right?
I'm referencing the fact that there's testimony in the record from Ms. Jones and also Mr. Smith that they were treated in a more aggressive manner by Ms. Kinsler, yelled at. She was ruder to them. Admittedly, not the most serious questions in this case, but the point is they fit into a pattern which under the totality of the circumstances view, we believe shows that there was a race-based hostility. And let me give you some of these other facts, Your Honor. This is important. As the court knows from its decision in the Monroe case, discriminatory intent can be inferred from phony reasons for discipline alone. We have that in this case. Whether they're really phony or not, that is a question of fact, but we've alleged that they're phony. We believe there's good reasons to support that allegation. Also, there's evidence in this record that shows that Das, as I said, used the N-word. Comparators brought their children to work. It's undisputed. The comparators brought their children to work without any consequences. It's undisputed that Ms. Jones was the only person they could identify who had ever been disciplined for this alleged policy, which some of the witnesses said they didn't even know that it ever existed. It's undisputed that other comparators.
American employees who brought their children to work who weren't disciplined?
No, other white probation officers brought their children to work and were never disciplined.
And how does Ms. Jones know that?
She saw it. And it's undisputed that other white probation officers wrote letters to parents of juveniles and juveniles informing them that they need to comply with the conditions of their probation or they could get into trouble, and they were never disciplined. So those are the bases for the comparators in this case, and I submit that that needs to be considered again all together, not just cherry picking one or the other least severe examples and arguing that of course the workplace does not guarantee a frictionless work environment. This is not hostility. If I may reserve the 2 minutes for my rebuttal. Thank you.
Mr. Griffiths.
Good morning, Your Honors. May it please the court. Assistant Attorney General Carson Griffiths on behalf of defendants. This court should affirm the district court's grant of summary judgment for 3 reasons. First, Jones did not suffer harassment, let alone severe or pervasive harassment as required to make out a race-based hostile work environment claim. Second, there was no evidence that if such harassment had occurred, it was based on her race. And third, there was no abuse of discretion in the district court's decision to strike Jason Smith's declaration due to Jones's non-compliance with Rule 26. So turning first to the issue of severe or pervasive harassment, to survive summary judgment, Jones had to point to evidence of extreme conduct that amounted to a change in the terms and conditions of her employment. She did not. Rather than harassment, Jones faced routine workplace discipline for conduct that she indisputably committed. After all, Jones admitted that she called a superior officer unprofessional. She responded insubordinately to a superior's direction that she comply with the office's no children in the office policy. She passed a note to a juvenile court judge with information that her immediate supervisor told her to omit from a social investigation report. She refused to make mandatory revisions to a different social investigation report. She sent letters, to juveniles' parents and their schools that her department head, Avik Das, viewed as unnecessarily coercive. And she made inappropriate comments about Eileen Kinsler, her immediate supervisor in the department's official computer system. Now, for her part, Jones largely ignores this evidence on appeal. She persistently says that she was falsely accused of this conduct But again, she admitted to most of the misconduct underpinning the accusations against her. I'd like to touch on the 4 instances that Mr. Stein discussed today as supporting his alleged claims that there were false accusations of misconduct. So first, the issue of Ms. Jones bringing her son into the office. To clarify, she was not disciplined for bringing her son into the office. As Avic made clear, and as his decision letter sets forth, she was disciplined for responding insubordinately when told to comply with that policy going forward. She essentially told Deputy Chief Probation Officer Kelly, I'm not going to listen to you anymore. I'm only going to listen to directions from the sheriff, circumventing the department's chain of command. That's insubordination, not violating the no children policy. Next, the coercive letters that she wrote. Jones, on appeal, points simply to her declaration to support her assertion that these letters were proper. In her declaration, she says, there was nothing wrong with these letters, but this court has made clear in the Title VII context, an employee's subjective view of their own performance cannot withstand summary judgment. And regardless, as Das made clear in his deposition testimony, even if there was some factual statements that were technically true, the tenor of them was too coercive because they suggested a juvenile would be taken into custody if he didn't comply with Ms. Jones's directions, and also that a juvenile's parent could lose custody of her son if she didn't comply with Jones's directions. So they were, on the whole, even if technically accurate, improperly coercive. Next, this idea of making the revisions to the TL social investigation report and the human trafficking assessment that Mr. Stein referenced. Jones's claim was premised on the notion that making those revisions would require her to perjure herself to the juvenile court. But the only falsehood she identified was a statement that Ms. Kinsler told her to insert that it was her understanding that a human and trafficking assessment had been completed and was submitted to the court. Jones, according to her, couldn't say that because she didn't have a copy of the report. But at her deposition, she also admitted that the report's author told her that she prepared the report and filed it with the juvenile court, which was in fact true. It was filed in April 2017. And Kinsler's revisions made clear, as Jones said, that PO, Probation Officer Jones, quote, does not have a copy of the report at this time. So there's nothing false about the revisions that Kinsler told her to make. And regardless of whether that edit was factually accurate or not, there's no dispute that Jones defied Kinsler's directions to make the edit, and then ultimately resulting in the department being embarrassed in the eyes of the juvenile court. Finally, the accusation that Jones called Ms. Kinsler racist, even assuming for purposes of summary judgment that she was falsely accused of making that statement, it had no effect on the conditions of her employment because it was not reported to Director Das until Das had already suspended Jones. So she was not working when that was related to Das. There could be no change of her to her employment conditions at that time, and she never returned from that suspension. So although that comment factored into Das's decision to discharge her, Jones disclaimed reliance on that discharge as the sort of severe or pervasive harassment forming the basis of her hostile work environment claim in response to our motion for summary judgment, because she knew she had an exhaustion problem if she did so. So, and even I want to now turn to the issue that even assuming there were questions of fact as to any of those facts, which there are not, there was no evidence that any of them were motivated by race. The evidence showed that Das terminated Ms. Jones for the reasons set forth in his decision letter, every single one of which was related to her job performance, not her race. That fact was undisputed by Jones in her response to our Rule 56.1 statements of material fact. So even if that decision was harsh, or if it was unfair, or if it was factually mistaken, it wasn't race-based. In fact, even if it was motivated by personal animus, which, to be clear, there is no evidence of such personal animus, but even if there were, that would not be enough to survive summary judgment on a hostile work environment claim based on race.
What about Mr. Stein's argument that the comparators that Ms. Jones has identified support that it's race-based?
Right. Neither of those comparators would raise a genuine issue of material fact. As this court has made clear in both the Title VII context and in the hostile work environment context, employees accused of misconduct have to have similar instances of misconduct. There can't be distinguishing features that would give the employer reason to treat the employees differently. So for instance, in this court's decision in Reed, the court held that the fact that the plaintiff had multiple instances of violating an attendance policy and had been told to comply and still violated it set her apart from other employees who had maybe only a few instances of violating the attendance policy. Here, the comparators are even further afield than that, far further afield. So Ms. Patla, according to Ms. Jones, quote, incorrectly submitted a custodial sheet to the juvenile court. And Mr. Grunauer failed to log into the computer system and failed to complete work. Neither of them had instances of direct insubordination like Ms. Jones. Neither of them said, I'm not obeying your orders and I'm not listening to you about any policies, which is exactly what Ms. Jones did. As for the comparators who brought their children into the office, again, I just want to emphasize Ms. Jones was not disciplined for bringing her children into the office. It was for her response when told to comply going forward. So that sets them apart. As for Director Das's use of the N-word at a meeting of African-American employees, the evidence showed that he read that word off of a document in front of a group of employees in early 2016. Ms. Jones was not present for that meeting. It occurred over a year before her performance issues began, and nearly 2 years before Das decided to terminate her, and notably over a year before he was even made aware of all the allegations brought against her by Deputy Chief Probation Officer Kelly and Supervisor Kinsler. So there's really no evidence there that that comment was in any way connected to Das's decision to suspend or terminate Jones, nor was there any connection between Das's statement and Kelly and Kinsler's interactions with Jones. And again, that was the conduct that formed the basis to ultimately discharge her. So it's just not enough to create a genuine issue of material fact here. Finally, with my remaining time, I'd like to briefly address the striking of Smith's declaration. Jones did not disclose Smith as a potential witness as required by Rule 26 until discovery was virtually closed. Only one deposition was remaining to be taken. She identified him as a source of documents in an earlier response to an interrogatory, but that does not comply with Rule 26's disclosure requirements. There was no indication that he was going to be a potential witness supporting her claims. And in any event, any error in striking the declaration was harmless because it wouldn't have created a genuine issue of material fact. The comparators in Smith's affidavit also did not have the same history of insubordination as Jones. They committed other types of misconduct like using drugs or submitting incorrect paperwork. And the general statement that Deputy Chief Probation Officer Griffin raised her voice and acted in a condescending manner towards certain African-American officers, not Jones, was certainly not evidence that she engaged in a severe or pervasive race-based harassment toward Jones. So unless this court has any questions, we ask that you affirm the district court's judgment. Thank you.
Thank you. Mr. Stein?
Thank you, Your Honors. Let me talk briefly about Das's comment. This court's holdings in the Rogers case, and the Johnson case, and the Schwab case make the following clear. A ranking senior supervisor's use of a racial epithet is significant when assessing if it creates a race-based hostile work environment. And these cases also establish that knowledge of a racial epithet is something that should be weighed when considering how it defined the work environment and whether it created a race-based hostile work environment. Again, this is not the only factor in this case, but the use of the N-word by the uppermost director of the department that Jones found out about is a significant factor. And let me just be clear on the chronology. Ms. Jones was employed at the department from February of 2015 to March of 2018. The epithet was used in May of 2016, and Ms. Jones found out about it from an email from Mr. Smith on May 30 of 2016. Unlike the cases that were cited by the district court on this issue, where the utterer of the racial epithet was not in the chain of command of the listener, or the listener heard about the utterance some 8 months after it was uttered. That is not the case here. So it is an important factor to consider. Again, not a dispositive factor by itself.
Does it matter that he was not addressing a particular person, but rather reading from the document?
Well, that was what Avik Das tried to explain. And before he issued an apology letter and after he flat out denied using the racial epithet. It is not how it was construed by those in the room, and we know that from Mr. Smith. It is not how Ms. Jones understood it when she heard that it was used. So it's the impact on Ms. Jones that controls whether she believed that she was experiencing a race-based hostile work environment. I see that my time is up, Your Honors.
Thank you, Mr. Stein. And Mr. Stein, you were appointed in this case to represent Ms. Jones. Thank you very much for your appointment and your advocacy on behalf of your client.
My pleasure.
We
Thank you.
appreciate it. Thanks to both counsel. The court will take this case under advisement. Our final case for oral argument this morning is appeal number 25-1036, Wickstrom versus Airline Pilots Association, and both counsel are appearing remotely. So I see Mr. Green and Mr. Elliston. Counsel, can you hear me? Mr. Green?
Yes, Your Honor.
Mr. Elliston? Okay. We will begin with you, Mr. Green, whenever you're ready.
Thank you so much, Your Honors, and thank you for allowing our remote appearance here today. May it please the court. Good morning, Your Honors. My name is Andrew Green, and I represent the appellants in this matter. Your Honors, we are asking the court to reverse the dismissal below after the district court denied plaintiff's motion for leave to amend and remand the case for adjudication of our duty of fair representation claim. The case is about the union abandoning its statutory obligation under the Railway Labor Act to protect its members from unilateral changes to working conditions, and in doing so, left our clients, the pilots, without any meaningful representation. Broadly speaking, the case hinges on 45 U.S.C. 151. That's the foundation. The Supreme Court has made clear in Steele that when Congress authorized unions to act as the exclusive bargaining representatives, it did not give them such plenary power to sacrifice for the benefit of its members rights of the minority of the craft without imposing on it any duty to protect the minority. That principle applies here, although unlike Steele, which related to racial discrimination, you still cannot condemn and discriminate against the minority of the craft. An individual's own autonomy and control over what is put into his or her own body, again, is irrelevant and invidious, and discrimination should not be allowed. The Supreme Court also held in O'Neill that our decisions have long recognized the need for such an examination proceeds directly from the union's statutory role as the exclusive bargaining agent, again, recognizing the immense power and control the union does have. Your Honor, Congress codified the status quo rule in 45 U.S.C. 156. No intended changes affecting pay, rules, or working conditions shall be made unless there is notice and bargaining. That's the issue here today, the bargaining issue. Any violation implicitly would violate any document, whether that's the CBA or any other letter of understanding or letter of agreement. The United Pilot Agreement.
Counsel, do you dispute that the union had a good faith basis to determine that the vaccine requirement was permitted under the CBA?
Your Honor, we do. So it's a two-part question, Your Honor, and I appreciate the question because it's going to lead into a further argument that one of the areas that you are allowed to find a breach in is the bad faith argument. Nowhere explicitly in the CBA does it allow for the control over medical, submission for medical examinations or physical examinations, as opposed to other cases. Your Honors, in the appellee's brief, they rely on two cases similar to this one, talking about vaccinations. It's on page 29 of their cases, of their briefs. They talk about the Stevens case and the SWAPA case. Stevens implemented the COVID vaccine, but the court recognized that the CBA and the language of the CBA gave such a broad management clause that the aircraft could submit the employee to paid medical examinations, and thus it was implicit that a vaccine requirement could then stem from that. Similarly, in SWAPA, it was the labor union who filed suit against Southwest Airlines for failing to maintain the status quo. The court again finds this broad purpose in the CBA. Unlike that, Your Honors, in our CBA here, the United Pilot Agreement, there is no reservation for physical examinations, submission to physical examinations, any control over the vaccine or medical requirements of the individual pilots in this matter. I also recognize that the appellees consistently cite to Conrail, and that case again hinges on the fact that there was a policy or custom of submission to undergo physical examinations. And the court held there, ALPA uses this as both an argument that it's a minor dispute and the system board should have exclusive jurisdiction, removing this court's jurisdiction, but also stating that there's no arbitrary conduct here. Again, the inclusion of drug testing and a history and practice of drug testing in that matter is what led them to believe that it was a minor dispute, and thus requiring drug screening and urine analysis was okay. The only support that they cite to here, or refer to here, is the yellow fever vaccine. That's one scenario, Your Honors, in a long timeline that came out. I think the vaccine came out in the 1930s, maybe for the benefit, let's say it was administered to pilots in the 1940s. We're talking about one scenario in the last 85 years, as opposed to here, in Conrail, they were doing routine physical examinations every single year, Your Honors. If I may, Your Honors, a lot of this case is going to hinge on the fact that the implementation of the vaccine was a change in working conditions as outlined by the Railway Labor Act. And I understand appellees are going to argue that it was, a pilot qualification, that they filed this grievance to even argue that it was a pilot qualification.
Do you lose if we agree that this was not a major dispute, it was a minor dispute and had to be arbitrated?
Your Honor, I appreciate the question. I think it's a very complex question because a lot of our argument is going to hinge on the substantial change in working conditions. If you find that as a qualification anyway, Your Honor, the court would still have jurisdiction because there is still an injury in fact. The pilots
Not
have
a
been terminated.
jurisdiction question, it's a merits question. So if we agree that this is, with Mr. Ellison, that this is not a major dispute, it's minor and needed to proceed via arbitration, can you still win on the merits of your arbitrariness argument?
So in that case, Your Honor, no, I would have to submit to the position that you're taking there, that if it is a minor dispute, the court has long held that minor disputes are for interpretations of the CBA themselves, and the arbitrator would have exclusive jurisdiction. However, this court has also found that when there's implementation or the attempt to create a contract or a change in term of contract, and that was in the Chicago and Northwest Transportation Corporation matter, heard before this court in 1987, that would constitute a major change, which again, I believe, Your Honor, with the implementation of a COVID vaccine, where you're literally changing employment contracts to require vaccination, that is a major dispute. That's not an interpretation of a CBA. And Your Honors, I do see that there's 3 minutes left. I would ask the court to reserve the remaining of my time for rebuttal.
Certainly. Thank you, Mr. Green. Mr. Ellison?
Thank you.
Good morning, Your Honors. Thank you for hearing me this morning, and thank you for allowing us to participate remotely. I'm Josh Ellison for the Defendant Appellee Airline Pilots Association. I'll briefly discuss why the plaintiff's claims here are unripe, and then turn to the merits. ALPA is pursuing grievances on behalf of each of the 7 pilots, alleging that United's termination of them for not complying with its COVID-19 vaccination mandate violated the collective bargaining agreement between ALPA and United.
What's the status of those grievances?
Though they are pending, 6 of them are pending right before the arbitration stage at the request of the plaintiffs. The plaintiffs asked that we not advance those to arbitration until they are until this litigation is concluded. And one of them is pending in an earlier stage, what's called an on the property, at the first hearing, after the first hearing with the company, because plaintiff Ellis says that he does not want to go forward until ALPA satisfies him that it will protect his constitutional right to privacy. So they are, as of now, these are all being essentially in abeyance at the request of the plaintiffs.
Mr. Ellison, while the grievances are being pursued, what's the status of the individual's employment? In other words, are they officially terminated and are they at home, or are the terminations held in abeyance? What, are they stayed? Like what's going on?
The plaintiffs are in an unpaid status. They are not being paid. They are not flying. The status quo is they are no longer performing active service for United. If we were to prevail on the grievances, if that was unjust, one of the relief that we would be asking is for back pay, that they should be made whole for that, for the time that they've been out, but they are currently not working, not getting paid.
So if you do succeed on the grievances, then is it automatic that they would receive all of their back pay, benefits, seniority status, and all of those things?
It is not automatic. It would be up to the arbitrator. We will be arguing that they should receive full back pay, full benefits, and full reinstatement. But that's ultimately the extent of the remedy would be a decision for the arbitrator. It gets to one of the issues with allowing these cases to proceed right now, without waiting for the arbitration process to play out, is that at first United is not a party to this, and ultimately both the grievances that ALPA is pursuing, and essentially plaintiff's claim here is that United breached the collective bargaining agreement, and under VACA v. Sipes, the damages in this suit would be limited to the harm that was suffered that cannot be attributed to the employer. In other words, United is liable for the damages due to what it did, and it was the entity that imposed the mandate, and it was the entity that terminated the plaintiff, and ALPA would only be liable for the damages that could be attributed to its exacerbation of those harms. So that is one of the reasons why this case is premature, and it should wait until an arbitrator is able to decide whether United breached the contract and to what extent United is responsible for their harms before the court could meaningfully address ALPA's liability here. So while those grievances are pending, essentially ALPA is pursuing these termination grievances. It's also pursued the unfortunately unsuccessful grievance saying that the pilots should not have been terminated. They should have been treated as other pilots who did not get the yellow fever vaccine in a previous incident a few years ago, but should not have been terminated. They should have been placed in a temporary unpaid status. Unfortunately, we were not successful there. But the dispute here essentially is the plaintiffs are saying, well, we don't like the legal theory that you pursued. You're saying that provisions A and B were violated of the contract, but we say that provision C, you should have made that argument, right? So it's the whole ball of wax here is what provisions were violated, and of the UPA, and that is for an arbitrator to decide. And specifically under the RLA, federal courts don't have jurisdiction to determine those disputes. Those are explicit, under Conrail and its progeny.
Counsel, if I'm reading your brief correctly, you're not just making an exhaustion requirement. You're also saying that because of the pending arbitration, that could render it moot, and therefore we don't have jurisdiction now. That to me seems to be shoehorning exhaustion into our jurisdictional jurisprudence. Can you explain what you're trying to get at there?
Sure. Yes. So you're correct that we are making the argument that the pendency of the grievances and the possibility that they will render these plaintiffs damages, or they will make these plaintiffs whole in that forum, deprives this court of jurisdiction, because at this point it's an abstract contingent harm that they've suffered, because they could be remedied through this other congressionally mandated process. So that is in fact we aren't making the exhaustion argument, but we're making the jurisdictional argument. And for instance, in the Jennings case, this court found that because the patent office proceedings had not concluded, and the plaintiff was suing over, third parties for alleged malfeasance and fraud on the patent office. But because he hadn't actually suffered any harm yet, because the patent office hadn't denied his application yet, that claim was unripe.
But why
So we
isn't
think
this
that's
different? Because as the district court found, they've already been terminated. That's the harm.
Well, Your Honor, I respectfully disagree, because their terminations aren't final. Because if we succeed on the grievances challenging the termination, they will be reinstated. They will almost certainly be reinstated. That if the arbitrator says that United lacked just cause to terminate them, they will be reinstated, and we will also be arguing for back pay. So their terminations aren't final. There's still a process going on the property through the process that Congress has commanded unions and air carriers to set up that will resolve that. So that's why we think the claims are unripe. Then just briefly on the merits, Your Honors, below and on appeal, the plaintiffs have failed to address the fact that the UPA has a provision in Section 21K that says that United can change personnel policies if as long as it provides notice to ALPA. And there's no dispute here that ALPA provided notice. And ALPA's duty is not to make the decision that the plaintiffs may have agreed with, not to make the decision that a court may have agree with respect to analyzing the contract, but just to make a rational decision. That's what the Supreme Court teaches, and ALPA v. O'Neill is reserved to unions. So as long as the union makes a rational decision and there's no evidence of an invidious motive, then the courts are to leave those decisions to the unions. And ALPA, after a 2-day hearing, issued a decision about this issue of whether there was the violation of conditions of employment. And it said the contract reserves United the power to change these policies, to change personnel policies. And we submit that there's no way that can be deemed a wholly irrational, in the words of ALPA v. O'Neill, a decision to conclude that based on the contract, United did have the right to do this. There's no evidence. The other prongs of the ALPA v. O'Neill test are discrimination, which is invidious. There's no allegation here that ALPA even knew the medical status of any of these individuals. People who didn't take the vaccine for medical reasons or religious reasons were all treated the same. As the court noted, ALPA simply did not challenge the mandate. There's no allegation or evidence that ALPA was improperly motivated. The other prong is bad faith, which is improper purpose, self-dealing, not acting in the best interests of the unit, and there's no allegation here. In fact, the allegation is that ALPA was motivated to help United obtain federal funding to prevent layoffs, which, as the district court said, well, how can that be an improper motive, protecting pilots' jobs? And I see my time is up, so I would just ask that the court affirm the district court's decision. Thank you.
Thank you. Mr. Green, rebuttal?
Thank you, Your Honors. Just to begin with the ripeness arguments, Your Honor, that was already addressed by the court below. And one of the supporting citations that the appellees use in the matter is Rios O'Donnell, which ironically is the exact same judge who presided over this matter, Judge Kennelly. And in their brief itself, they omit the latter portion of their quote, saying that a claim is not ripe until termination is final. And as Your Honors just correctly noted, and I heard opposing counsel kind of jump around the issue, my clients have been terminated for several years now. He said something along the lines of they're currently not engaging in duties. That's equivalent to termination. The grievance review panel refused to take this case forward to arbitration years ago. The latter argument that the amount of damages could be compensated, which would render this case moot, is such a frivolous argument. Even if back pay was awarded here, which is not even a concrete finding, it still would not make whole the past constitutional or federal or statutory harm that occurred here. The status quo grievances that were filed, Alpha failed to give any of my clients support on, and they've been done for years now. I do want to go to Baca v. Sipes for a second, because I know the appellee just talked about it, and I think it's a good contrast to our case here, because in Sipes, the union, again, helped the plaintiff in such a regard as to even providing their own doctors and even funding the doctor visits for a plaintiff to resume work. Here, Alpha refused to join the plaintiffs in filing their status quo grievances. They did nothing to assist in gathering evidence, which opposing counsel just admitted to, that the vaccine could even be harmful to their individual health conditions. And then they advised union leadership not to even interact with the plaintiffs in this matter. So they're completely analogous to each other, Your Honor. Your Honor, as it relates to pursuing of grievances, and I heard opposing counsel talk about they filed their own grievance. When they filed their pilot qualification grievance itself, Your Honor, the arbitrator did render in that opinion that it was not a pilot qualification. So the only rational outcome would be that it's a change in working conditions. It's either a qualification or a change in working conditions. That put them on notice that they had to act, and they knew about the Railway Labor Act, which any change in conditions, they had to bargain for. They did not do so here. The last point I'll hit on the last 10 seconds is 21K. The change in company personnel does not at all give them express authorization to mandate vaccines. All it is company personnel. It's not akin to attire. Your Honors, thank you for your time today, and thank you for hearing this argument.
Thank you. Thanks to both counsel. The court will take this case under advisement, and that concludes our oral arguments for today.